So as promised, I think we have the major debate on how courts should behave, major debates on how the courts should behave, a position in that debate, and an empirical argumentation on how the Indian courts are behaving. So I think we are now open to debate. Questions?
Yeah.
Yes, right here.
You were mentioning this idea of popular narratives. Single governments you have in the 50s, 60s, it's sort of providing checks and balances to government and letting get out. And from the 90s, in the context of corruption. And would one resurrect something which is sort of completely status? So Benjamin Cardozo's idea, the mores of the time.
Yeah.
Influencing that. So is this another sort of articulation of that kind of mores influencing that?
Okay.
Are there any related questions? Or?
Not being a lawyer, not being this manager, Bhopal
Yeah.
issue. I would like to discuss that, where it stands, and whether correct decisions have been taken.
Maybe I just had a
Yeah.
related question. Are you equating public reason with the kind of ideational milieu that is created by the ruling party in power? Is that? I mean, I think that idea of public reason came out very forcefully, but in answer to our questions, I think, how can we really operationalize public reason in a non-tautological way?
So, just to build on that question, where does the media stand in this process?
So, thanks. That's actually helpful. So here's the challenge, right? Which is, so if you take Cardozo's mores of its time, right? I think the fundamental problem all our democracies are struggling with, and Indian democracy in particular, because of the structure of the media, is, suppose you take a relatively empirical view of public reason, right? Which is the test of whether something passes public reason, although it's supposed to be a normative claim, but is if people actually accept it as right, reasoning impartially and fairly. Question then arises, how do we actually know what public opinion is, right? In a case like India, and I think this is one thing all democracies, actually not just democracies frankly, I think almost all political forms are struggling with, which is public opinion can itself become a reflexive construct, right? So, I think I know what public opinion is because somebody is telling me what public opinion is, right? You could take a crudely empirical view of public opinion, I mean, not in favor of it, but let's say, for at least in principle for arguments, you could say, look, could you just ask people, could you just run surveys, could you just do polls, right? I mean, that's somehow right. And there's a question about what those actually reveal under what circumstances, right? But one of the big challenges both judges and politicians are facing, right, is they have to, in a sense, intuit this public opinion, right? I mean, in the sense that, by intuit I mean something very specific, which is, some are better at it than others. Obviously, some politicians are more successful in understanding what public opinion is than others. But you can't pinpoint a process by which you can say, okay, it is because of this process that they have come to a much firmer or better determination of what public opinion is, right? So I'm not saying that, everybody's in the same boat. Obviously, if some people manage to, at least post facto, we can say they were much better at figuring out what public opinion was than others, right? But it's intuitive in the sense that there isn't a process associated that can tell you about the reliability of your judgment in this one. what is that process? The fact that you watch Times Now, right? The nation demands. I mean, I'm not. I mean, this is actually a kind of half-serious program, both in the anthropology of judging that has become a big issue. Actually, you know, what happens in court partly dependent, in some cases, on what happened on TV last night, right? But in a more serious way, right? What is the process by which you actually discover this mode of public reasoning, right? Okay. And under that garb, right, in some ways, whether what you have intuited, right, you can actually know whether it's public reason only post facto, right? Now, one example or one way of thinking about it is the following, which is take the whole debate about judicial appointments in India, right? Which everybody knows, most scholars seem to agree that the 3 judges case, right, was on some traditional readings of the constitution a constitutional travesty, right? The idea that judges should have monopoly over appointments towards, not that a monopoly, but have the final say in appointments towards to the Supreme Court, right? Was against the spirit of any mode of appointment envisaged in the Constitution, and you should argue why should only the judiciary decide against some appointments, right? But clearly the judges read the underlying political narrative broadly right. Because the underlying political narrative was, we were in a frame of mind where we distrusted the executive and legislature in the matter of appointments more than we distrusted the judiciary. Okay? So for 20 years this was the kind of de facto consensus, right? It's not an accident, right, that as tales of judicial corruption grew, right, or as, let's put it this way, the judiciary itself was subject to scandals, right? That's the political moment at which the idea of a national judicial accountability became just much more acceptable, right? Overnight there's an all-party consensus. Now politicians always had an incentive to do it, right? Because, you know, institutionally that's what they would like, a greater say in judicial appointments, right? But the fact of the matter is that for 20 odd years they saw a political risk in going down that path, right? Because of that kind of underlying narrative that by and large we trust judges more than politicians to do this job, right? The conditions under which that narrative exploded were exogenous. Yeah, exogenous in the sense that, you know, you could imagine a counterfactual in which strong institutionalized chief justices could have exercised enough internal discipline, the crisis in the court would not have come to this point, and politicians would have been afraid of enacting a bill like this, right? But in the determination of what will pass muster, right, frankly what's going on is not, again, you know, reference to this article or that text, right? What is going on is this intuitive grasp of what we think public opinion, what are these motives? And, you know, that old question we used to set in exams, which is, ask yourself the question, what do you fear more? And that will give you a clue about where you will come out on certain things, right? So, do you fear, and it is surprising that at this particular moment, the fear of judicial corruption became at least as much of a worry as the fear of executive or legislative usurpation of judicial independence, right? Neither of these two are first principle arguments, right? Both of them are emerging democratic realities, right? And how do you grasp which is the bigger fear? What's your underlying theory of which is the bigger fear, right? So certainly the media story plays a role in that, not so much because media is necessarily reflecting public opinion. I mean, we can talk about the structure of the Indian media and why it doesn't. But because it certainly can be taken to represent the Indian public opinion, which is reflexively, that's how a conception of public opinion is constructed. I'll come to your question, Gopal.
Just to understand the theoretical part, I understand in other case, it might be one level, you try and read the judgment, find there is intricacy in the judgment. You have a series of, say, being matters, what is there, there is what is. And you try and say, where is the court coming from? You think of it pragmatically, it works very well, as the evidence doesn't work. It seems to address this concern that you have these godowns full of food which are rotting, and the state can't distribute them, so the court comes in, comes up with a naming scheme which is guarded by progressive. Puts it to like it. The problem with the theoretical framework that we set up is there isn't really public reasoning. In terms of the court has never really spelled out how do we read this. But it seems to have also been caught up by the political executive. Now you have the food security bill, so Sanjay Rukredi argues this is a case of the court having read it well and now it's become a political issue. And the court should be given some credit for starting a whole welfare rights revolution or something like that. But I suppose the difficulty is when you look at it from the conventional point of view, you don't know how to evaluate it. It seems to fit your criteria of it was in the popular narrative, it's a role, but it still leaves you with some discord in terms of how do we look at it and how do we distinguish this from, say, a bad case, which, as you said, the reasoning is bad, you don't know how to evaluate it. So I'm just trying to see how will we use your framework to understand the other things. Maybe this will help you explain.
Can I just supplement that comment? Can we argue, Arun and I think we are kind of moving in a similar direction, that what the court is doing is basically picking up not the basic structure of the constitution, but rather the basic structure of changing ideas within government. And so, for example, when the court tells that you should have a telecom regulator, it is arguing in favor of the Prime Minister's office and the Ministry of Finance and against the Department of Telecommunications. But telling you about an existential reality, which is that you have asked private operators to come, and without a regulator, we are all messed up. It's I think a similar impetus to the kind of. Do you have something to do?
have something similar about right to information section. Similar kind of a question about court interpreting a certain article in the Constitution continuously, but entry points are different. So initially the entry point is the press, in relation of press with the political executive, political class, and then it becomes politics itself. The Rajnarayan case, and later on it becomes a public cause. And here we see judiciary kind of interpreting the Constitution in a certain way, which is one of your theoretical postulations as well. So isn't this the case then that the carrier of ideas in this case was the judiciary and the Constitution rather than the public opinion, external public opinion?
Good. I mean, this is really big cases, and I think there's a narrative connected with that. I'm glad you brought up the right to food one, because it is a hard one, and my reading of it is actually completely the opposite of Sanjay. But it has actually, so maybe it turns on a substantive difference, which is I think the way to think about that case, and in the sense even the telecom case, right, is clearly the court perceived a problem, and it came to a determination of that problem actually because it was put out in the public domain, actually the media. I mean, you can't put this in any political science paper, but we know for a fact that the judges, relevant judges, came to court that morning and said, we switched on our TVs last night and we saw this, and how can this happen? I mean, that was literally how the story began. But that's all the interesting data you have to leave out, right? But more seriously, more seriously, right? The right to food thing is in a sense interesting, because if you take the right to food, the right to education, even the right to information in some ways, I would argue that the court was actually behind the curve. And it was not just behind the curve. When it actually decided to jump on that wave, it actually completely misread the direction of that wave. Okay? So right to education comes at the moment in India's history when enrollment is near 100%. Okay? Your big problem is a very different problem. It's not the problem of inputs and teacher salaries, which is essentially what the right to education did, right? The right to food comes when your big challenge is actually malnutrition. It's not mass starvation. And in fact, the entire edifice that the court created, why a lot of it is an economic waste, was actually geared towards as if what you were trying to do was solve the Great Bengal famine, which isn't the problem. The problem is really chronic malnutrition, right? The problem is the movement away from grains, right? The reason you have food stocks has nothing to do with food security. It has to do with minimum support prices from farmers and agricultural subsidies, right? So if you look at the moments at which these cases come, they come at a moment where actually it's true that the underlying dynamics and demand are already moving in that direction. Chhattisgarh, Tamil Nadu, they're already going for universalized PDS and stuff, right? What the court does is it takes a particular slice of it, right? As also it does in telecom, right? Of course, we need a regulator, but right. And then I think the interesting challenge happens for public reason, which is really the point, both in the right to education case and in the right to food case, which is the court actually relies on arguments that are presented before it in court, right? I mean, so now the court has to act as social scientist, right? Effectively it does. I mean, that's what it needs to do if it's going to come up with a disciplined determination of what an appropriate form of supervision should look like, right? It doesn't have the intellectual resources and means to do it. It relies on particular submissions made to the court, which itself is, in a sense, if you like, captured on both sides in different ways, right? Okay. So, for example, in the right to education case, I mean, just very straightforwardly, right? The court, for example, did not realize, still does not understand, that most private schools in India are actually low-cost schools. The entire judgment was framed as if this was a judgment about elite public schools in India. Okay? I mean, so the whole idea that, the problem is you need to regulate wages, the problem is, that's actually not the problem, the problem is out, right? An education establishment got hold of the right to education edifice, right? I mean, just again, to be fair to the court, it's not just the court's problem, but it goes back to the question of what is public reason, right? Here's an education establishment that says, we are okay with input-based legislation, right? But we will prohibit any output measurement of educational performance. I mean, it's a bizarre right to education legislation that prohibits the testing of kids till class 8, right? That says you will teach to the curriculum, you will not teach the child. You cannot hold a child back irrespective of age, right? Okay. Similarly with the right to food, right? Most states, the debate was actually not about, in a democracy, any government has to be committed to food security for democratic legitimacy, if nothing else. There's not a threshold below which it can go, right? But the demand was whether you could actually do malnutrition, whether you could do, in fact, I think the better investment of money would have been in ICDS, right? Because you could target expecting mothers and children. And that's where the malnutrition story begins. And you also don't have a targeting problem there, by the way, right? In the way in which you have a targeting problem in identifying people below the poverty line, right? Okay. So here's a court that interposes itself in a really complicated debate, right? Without actually the minimal intellectual resources and discipline to see what the full ramifications of this argument are going to be, right? So it would have been one thing if it had said, look, we think the right to food is important. You, the government, come up with a credible plan, right? Take it. Here are some parameters. We'll then, there could have been a dialogue on this. the fact of the matter is the court, in a sense, and that's the public reason point, it actually did not, it looked like it was going to open up a dialogue. What it ended up doing was usurping that space in ways that I think were institutionally quite counterproductive. Right? Similarly, in a sense, with the, if you look at the range of regulatory things in which the court has been involved with, the intuitive sense that there is a lag is right. I mean, obviously, if you have private payers, you need a form of regulation, right? You can't, right? Quite what that regulation involved and what are the range of considerations relevant to that regulation. The issue is that the court doesn't actually have, again, going back to the point, doesn't have a disciplined means of arriving at that determination. Right? That's where a lot of the argumentative burden is actually being carried not by the integrity of its process, but it's actually being carried by this, intuitive sense of what's, what will quote unquote fly, right? I mean, there's an imagined public, right? Which has itself not been articulated through, again, any institutional conception of what that public is, right? And it can't be, right? Because once you distrust representative process, you say, well, it can't be whoever is democratically elected because these are the guys who are the problem in the first place. Well, if they're the problem in the first place, then how do you, as you used to ask in the French Revolution, right? How do you know what the people is and what the people want?
I have two questions. One is perhaps related to what you have been discussing. The other one is not related. I will ask you anyway because it's really, what one hears about the Supreme Court from the sort of activist role in terms of public interest litigation. Also in relation to, say, the whole question of secularism on the highlight. But what about the role as a disciplinary court and as a supervisory court in terms of the legal system, in terms of the courts beneath, at the High Court, District Court, subordinate courts, and the huge corruption, pervasive corruption, which limits access to justice. So I find a kind of irony here. On the one hand, it's pontificating, telling different agencies and institutions what to do, how to behave. But it's sitting on that, at the apex of that huge structure, which itself seems to be mired in corruption. This is one issue. The other is really about what you highlighted very well, this sort of gray area in which the court is functioning. And this seems to me, if you take a long view, a lot of the gray area comes from not knowing what is good capitalism and not good capitalism. And of course, we are in this period of transition where change is very rapid. Are there other examples, other societies, where courts have followed a particular trajectory from where we can learn?
Two big questions. So the first one, you're right. I mean, I can just kind of refer to you to a paper by Nick Robinson and the structure of the courts. I mean, this has actually been a long-standing issue, and it's an interesting question why the court doesn't exercise. I mean, there are two kinds of issues. One is why the court has not been a more effective voice in demanding the kinds of resources that will allow it to do its job of justice delivery better, right? Frankly, its heart has not been in it. The second is how does it manage such internal hierarchy in the court that it actually does have? And frankly, I think one of the reasons you're actually getting this backlash against the judiciary, in part, is because that kind of tide has turned, which is you can't claim the mantle of effectiveness and being a more legitimate institution beyond a point if actually that efficiency is not actually percolating down. Not just not percolating down, but arguably, the idea that due process as punishment still kind of persists, right? So that's a. I mean, you're absolutely right. I mean, it certainly, I think, is a factor. I think in what you might see or say is going to be the relative downgrading of the authority of the Supreme Court as it happening when it's entirely kind of self-created. The second question about the regulatory part, and you know, the transition from crony capitalism to well-regulated capitalism, right? This is a genuinely hard one, and to be honest, most regulatory jurisdictions have learned it through trial and error over a long period. I mean, you know, we often have this kind of Whiggish view of, you know, somehow European or American capitalism magically created these rule of law driven attributes of capitalism. It's never the case, right? Actually, you know, in fact, if anything, it was actually sort of messier. And India is in that kind of moment. I mean, the right historical comparison is the transition from the Gilded Age to the progressive age, right? In some ways, right? To be fair to the courts, I mean, and you know, to this extent, you could argue that look, the courts can't be, and why I tend to be a little bit skeptical about courts as agents of legal change is that well, courts as agents of social change. I mean, they are agents of legal change. Obviously, that's the easiest thing to do. Is whether there's actually a proper understanding of the way in which new forms of regulation have to be embedded in society, right? So one example I'll give, I mean, it's kind of building on Rahul's example in the telecom sector, but you can generalize it. I think the last government, if I'm not mistaken, you know, if you just do a count, lost, depending on how you count them as significant cases or not, but lost 50 to 70 major economics and regulatory cases in the Supreme Court. Absolutely astonishing track record, actually. When you wonder what was happening to the Ministry of Law and you know, Attorney General's office. Now you could say they lost it for two different set of reasons. One, you could say, look, the courts were being capricious. The government was doing a good job. The courts were just, you know, I mean, you know, I gather T.N. Srinivasan did say it in this room, but somebody like T.N. Srinivasan would say the court needs economics 101. You know, and there's a certain element of truth to it in, you know, in certain contexts, right? But I think more than that, what I've been describing as a feature of the Supreme Court is also a general feature of the context in which regulatory agencies have been created and the way they have actually been designed, right? Part of this is because we've tried to do reform by stealth for too long, right? Nobody wants to come out and say, let's openly privatize, so you find, you know, half ways of privatizing, which is the worst of all possible worlds, right? Every single major sector, from telecom to coal, right, there's a kind of parallel story, right? There's an opening up, but you can't open it up on first principles, so there's a kind of halfway house constructed, which is a regulator, but it's not quite a regulator. I mean, I think the interesting question is, what is it about the political economy of India that's actually from the government side produced this kind of regulatory institutional design, right? I mean, Rahul has written on this in a couple of sectors, and you can say, if you're being sympathetic to the court, that the court has found no way of kind of transcending those infirmities, right? Again, A doesn't have often the intellectual resources to do so. One thing I will say, however, regulation, since we are in Singapore, I kind of be a little bit provocative and say it. Obviously, in Singapore, the ease of doing business is legendary and, you know, quite amazing. I mean, right? I'm not entirely convinced that we actually have a good measure of what makes for regulatory transparency and ease. And what I have in mind is following, and this is the provocative statement. You know, take a company like Google or Microsoft, right? It's actually interesting. There's one data point that apparently their legal budgets are actually higher than their R&D budgets. Okay. The point I'm trying to make is that what we don't see in well-regulated capitalism is actually the post-facto costs of regulation, right? I mean, so this idea that, you know, somehow costs of regulation are high in India, is cost, I mean, it's right. I don't think actually that's the issue. In fact, you could joke, you can actually argue, I mean, until the recent big infrastructure case, that in India the sunk costs are high. I mean, it takes a long time to get things started. Once you're started, you're actually pretty well protected, right? Often in other jurisdictions, it's actually the opposite, right? It's easy to start with them, right? So, you know, and this is true across a range of regulatory domains, from IPR to other, right? So I think it is a much more complex issue, and I actually do buy Edward Rubin's argument that there is something inherent to the logic of a modern complex regulatory state, right? That this kind of institutional architecture, right? Well, I mean, you know, you should read Arun's paper on regulation, the best history of the evolution of regulation, history, analytical account, right, of that. But if you examine the evolution, right, it is a kind of trial and error process. What you hope, and that was the big hope with the courts intervening, right? Whether the form in which that intervention would take, whether that dialogue would be a disciplined dialogue, right? So court says, you know, as kind of happened in the 1950s, okay, this is our take. Executive respond and say, look, this is a better way of doing things, right? Meeting the same standards. Is this institutional interaction going to be the form that produces a virtuous spiral of better reasoning? Or is it going to be, I don't like what you're doing, let me do it my way, irrespective of whether it actually passes the test of public reason?
I think we have.
Just one. So the reason I kept it last was, I'm afraid I don't have anything particularly new or intelligent to say about it. I mean, as you know, that case was a huge indictment of not just the Indian legal system, but the government of India, and many would argue Indian democracy. It's failures at almost every level, and ways in which we can't even imagine. Other than kind of marginal movement on the compensation, I don't know what the latest is. Frankly, there's just not been, you know, any tangible progress which you could, you know, classify as a kind of.
Audience knows what the subject is.
Yeah, I suspect this audience knows the Bhopal, which is the single largest industrial accident in modern history, 1984. And oddly enough, it was the one case where, you know, it was a very complicated story why the case was not tried in India, what the Supreme Court order was, which let Union Carbide off lightly, the political economy of the government's complicity in letting, but you know, essentially the Supreme Court said to the world on record that we don't think the Indian legal system can handle this case. I mean, apart from other things, that's what they said. And you know, maybe they were right about it. Initially, there was also a tactical decision that somehow if the court was, you know, the matter was litigated in the EU courts, the quantum of compensation would be different. But the amount of compensation that has made its way to the victims is just minuscule, small. I mean, it's you know, is this? I mean, you know, God forbid something like that, you know, shouldn't happen again. But would the court system be better equipped to deal with a smaller tragedy of that kind, were it to happen now? I think the only thing we can probably say is in terms of process that there's probably going to be a lot more public pressure than was the case in 1984 for a variety of reasons. So if this democratic narrative is right, at least the courts, the onus on the courts to appear to be more responsive will be much greater. But whether they can engage in the kind of disciplined forms of reasoning that we require to do it, we don't know.
I think with that final comment, let us join our hands in thanking Pratap for this simple. He has provoked us to think in a certain direction, and he's given a lot of evidence to convince us in that direction, and I think that debate can continue. Thank you very much.